Hey everyone, welcome to my channel on everything real estate. This is chapter 4. Today we are going to get into the transfer of title to real property, which includes knowing what property descriptions are. This should be fun. Must I say it again at this point? You already know that you should be subscribed so you can follow along, and it's a free way for you to support what I'm doing. I also have a 10% off sign up link down in the description below for these pre-licensing, post-education, and continuing education classes for new signups. And let's go. So describing property is more than just having an address. Some properties don't even really have an address. We need a formal way to describe a property, and we do that by using a legal description. This will give us the exact location. In North Carolina, we use the meets and bounds method, although in other parts of the country there is the government survey and the lot and blocks method. So meets and bounds. Meets is the distance and bounds is the direction. Point of beginning is the designated start and end place. Monuments are objects referenced when describing a property and its layout. Things like lakes, trees, stones, etc. And these are notated by the surveyor and are the most legally accepted for deeds. Then there is the government rectangular survey, which is the most common in the United States and was created back in the 1800s. It's a grid-like system. So all those squares that you see when you're flying over the western states, that's actually because of the government rectangular survey. Now you know. Pretty cool, right? The reason there is a grid-like system out west is because most of that land was undiscovered back in the day. So when the government was selling land out west without actually having discovered that land, it was much easier to say, okay, you get this 640 acres here, then the next person gets the other 640 acres on the other side, and then these 640, and then just continue going on. And this was much simpler than having these random, unique, imaginary lines that were based off of monuments that you can't see yet, or haven't been seen yet. They were basically imaginary lines where the government says, you have this imaginary space over here that no one has seen yet. Hopefully you like it and it's suitable for what you want to do on that property. So now let's break down the townships and their designs, which townships have to do with the government rectangular survey. A township, which is a square, measures 6 miles by 6 miles and is broken down into 36 total sections. So if you're to do 6 times 6, you'd get 36 sections. So each one of these boxes here, or sections, is actually 1 square mile. It's 1 square mile long and 1 square mile deep. Each of these sections measures 640 acres. So there will be some questions on the test asking you how many acres a certain lot is by giving you a description. So the legal description will look something like this: the north half of the southeast quarter of section 5. This looks crazy, but it's actually very simple. Let's dig in. So take your township, get to section 5. It actually really doesn't matter which section because all sections are the same. They're all 1 square mile. They're all 640 acres. So you just work the description backwards because the northeast half of the southeast quarter means you work it backwards. You find the southeast quarter first so you can find the half of that. But really, so it doesn't even really matter if it's southeast, north, whatever either. You take the 640 acres and you find a quarter of it. We're looking for the southeast quarter, but any quarter. A quarter of 640 acres is 160 acres, right? So then we need to find the north half of 160 acres. Half of 160 acres is 80 acres. It's really that simple. You just keep chopping up the 640 acres until you're done with the legal description. Because sometimes this will go to southeast quarter, north half, south half, east half. It'll just keep going. You just keep breaking that 640 acres up, and that's how you find the amount of acres the end lot that they're looking for needs to be, or is supposed to be. In this scenario, the lot described is 80 acres. Other things you'll need to note, and these are just things that you'll need to memorize. I'm going to read them off here so I make sure I just get them crystal clear for you. The baselines are the horizontal lines in the grid dividing the sections, so they're actually the lines between property lines. Those are baselines. The tier is the horizontal strip of sections themselves in the grid. So the horizontal strip of properties of lots. So you have your 640 acre lot, 640 acre lot, 640 acre lot. The meridians are the vertical lines in the grid dividing the sections. Again, The meridians are the lines that divide the properties. Then the range is the strip of sections going vertically. Again, 640 acres, 640, 640, and so on. And then lastly, there are informal descriptions, which an informal description is just having your property address 123 Main Street. This isn't actually a legal description for a property, although it's the most common one that you and I use. So this is used often in the listing contract, but should not be used in the actual sales contract. So now let's cover plat maps. So a subdivision is a piece of land that has been subdivided. Doesn't necessarily have to be a neighborhood though. Each subdivision needs to have an actual plat map because the plat map tells the government and tells the people what this new piece of land now looks like. It was a piece of land that looked like this, a big chunk. Now it's this piece of land that's all chopped up, has roads going through it, it's been altered, and the public needs to know what it now looks like. The new plat map is recorded and stored in the county courthouse. This is now a reference document where a buyer or a contract can now reference the lot and block, so lot 2, block 3, rather than referencing this complex meets and bounds legal description. So what you would do is just go check the records for lot 2, block 3, and then that's where you'll find the actual legal description for the meets and bounds. The deed has the description too. The last bit of information that you'll need when describing properties is the following. Surveys are not required in North Carolina, but as a real estate agent, you should always recommend it. You do not want to be held liable for anything. And lastly, before we get into the math section, there are 2 numbers you'll need to memorize, and I would write them down. A mile is 5,280 feet. A way you can remember this is by saying 5 tomato. 5 tomato sounds like 5280. 5 tomato, 5280. Kind of. And an acre is 43,560 feet. So you have a mile, 5,280 feet, and then an acre that is 43,560 feet. This one is a little bit trickier. Obviously, it's a longer number and probably less used. So something that may help you memorize this is thinking about 711. The first 2 numbers, 4 and 3, equals 7 if you add them together. And then 560 equals 11 when you add them together. What helps me actually memorize this number is just thinking about how most of these numbers are in order, 43560, except for there's a mistake in the beginning. I don't know, it's just a weird thing that sticks with me. 43560 is very close to 34560. Remember, your memory is like a giant microscopic spider web. The more ways you can build relationships to a certain thing in your mind, that builds more bridges and more webs to connect to that same certain thing in your mind. So think about this being the number 43,560. Now I have 711 over here in my brain connecting to it. Then I have, it looks like it's almost in order except for the mistake in the beginning, 34560 connecting to it over here. Then I could have something like, it looks like, or it could be said, my 43-year-old mom was driving 50 and a 60, and put that over here. Now I have 3 connections tying 43,560 into all these things in my brain, and so hopefully I never forget it, at least not until after the test. We are going to split up the property description section of this video with the transfer of title to real property section of this video with a little bit of super easy math. This should hopefully just be a refresher for you all. It's just multiplication and just finding the dimensions of a piece of land. If you don't even know the basics of math, still don't be discouraged. I would still brush over it. I would still learn these and put some effort into it. However, you can pass this test without getting a single math question right. It's a possibility, but you would have to get almost every other question correct. So try to get some of these easy ones done at least. So length times width equals the area. Area divided by the length equals the width. Area divided by the width equals the length. You'll see a couple of questions like this on the test, but take a deep breath and let's go. So you have a couple is buying a lot that is 40 feet by 110 feet. What is the square footage of the lot? You simply multiply the 40 by the 110 feet and you get 4,400 square feet. That one was a little too easy, hopefully. So the next one is an investor is buying a piece of land at $3 a square foot and is buying a total of 5 acres. How much does this cost? Well, remember, an acre is 43,560 square feet. Now we're talking about 5 acres. So we multiply that by 5, which gives us 217,800 total square feet. Now we said each square foot costs $3. So now we multiply that 217,800 square feet by $3 to get a total amount of $653,400. Again, hopefully still pretty easy. Let's bump it up one small level here. A building is 30 feet long and 20 feet wide and now 15 feet tall. How many cubic feet of space is in this area? Now we have to take into consideration the height. So now we are working with 3-dimensional area here, but don't let it get to you. It's actually just as easy as the first one. You just multiply all 3 numbers to get your answer, but let's just start with the base. It's 30 times 20, which is I think 600 square feet for just the floor. Now you multiply that by the height and you get a total of 9,000 cubic feet. Let's do one more at the absolute hardest level. If one rectangular piece of land containing 1 acre is divided into 4 lots, and each lot has 60 feet of front footage, how deep are the lots? So write down what you already know. You know the entire lot is 43,560 square feet because it's 1 acre, and you know each lot is 60 feet of front footage. So you multiply that by the 4 lots, which will give you 240 feet of front footage. So now you just divide the entire lot, the 43,560 square feet, divided by the 240 square feet to get a lot setback of 181.5 feet deep. And then now you can go ahead and just double check yourself. Multiply that 181.5 feet times the front footage of 240 feet, which will give you the same area of 43,560 square feet. Boom, easy. Let's move on to methods of transferring title. There are 2 ways to transfer title, one being voluntary or willing, like as if you were to sell your property, and the other way would be involuntary or unwilling, like a foreclosure. Then we'll break out the 2 ways to die. Sounds a little morbid, but it's important. We have testate, which is where the owner dies with a will, and so the property will then go to the people listed in the will, unless it's tenanted by the entireties, which we'll get into a little bit deeper here in a little bit, where the property will actually go to the other owners of the property. Then we have intestate, which is where you die without a will. This is where the property will pass to the heirs, and if there are no heirs, it escheats back to the state. So if you don't want to give your property to the government, make sure to update your will if you don't have any kids. And remember, we brushed over this in other chapters, but the deed is the conveyance document that transfers the real property from the seller to the buyer. Alright, so let's go over some vocab here. Devise is the gift of real property with a will. So if you were to die and you have somebody written in your will, devise is the gift of the property. Descent is when your property goes to an heir when you don't have a will. It's kind of like an automatic thing. Beneficiary is the person that is the heir of the will. Kind of think of it as the person benefiting from the will. This is probably a good time to go over or and e. When the title or role of somebody ends with or, they are giving something. When a title or role ends in e, they are receiving something. The grantor, the giver, is giving the deed to the grantee. An offerer is giving an offer, and the offeree is receiving an offer. Alright, let's go through the involuntary transfers now. This can happen because of lien foreclosure, adverse possession, escheat, and eminent domain. Alright, lien foreclosure. A lien foreclosure is just your standard foreclosure. This becomes a material fact once a formal action has been filed. A material fact is anything that would cause a buyer not to buy or a seller not to sell. These are things that I should have known or do know, and we'll cover this more in other chapters. Alright, adverse possession. I'm going to read this one off. Adverse possession allows trespassers who openly inhabit and improve a vacant property to obtain the title if certain conditions are met. And those conditions are met through an acronym we use called OCEAN. Again, OCEAN, just like deep sea that we learned about in earlier chapters, has nothing to actually do with the ocean or the deep sea. So we have open, continuous for a time period of 7 or more years, exclusive, adverse, and notorious. And we'll actually cover OCEAN again in future chapters and go further in depth in this acronym. See, this whole thing is all full circle. Eventually, when you watch this entire series, things are going to start connecting to previous chapters, and things you learn now, you'll end up relearning again in later chapters. Don't stress out so much. Escheat. So escheat is when the title is transferred when somebody dies without heirs. Then there's eminent domain, which is where the government can take the property and use it for the better public use, whatever that means. The right of the government to do this is eminent domain. The actual action of them doing this is condemnation. Furthermore, if a property that is under eminent domain is being leased out to a tenant, both the tenant and the homeowner will be compensated, although the tenant will still have to be kicked out. Alright, let's head over to deeds and transfers. A deed does not need to be witnessed or acknowledged to be valid, but they should be. There's a few requirements for a transfer, and they are the following. Must be in writing, must be in legal capacity, so someone can't be drunk, identification of parties, words of conveyance, property description, signed by the grantors, and delivery and accepted. They do not need to be notarized to be valid, but they do need to be notarized to be recorded, which gives it the public notice. Being recorded and given public notice makes it enforceable. Alright, there are 4 types of deeds, and I have them listed between the most promises to the least promises. You have general warranty, you have special warranty, you have bargain and sale, and then you have quitclaim. Let me read this off so I just make it crystal clear and as accurate as I can for you. So general warranty deeds are deeds with no encumbrances and provide you with quiet enjoyment, and it's warranted against any claims back to the beginning of time. So if someone comes out of the woodwork and tries to take claim of the property, nope, you've got a general warranty deed. Alright, special warranty deed. A special warranty deed is a limited deed with limited promises. This is basically saying that it is only warranted up to the term of the previous owner and usually delivered by builders and developers. This doesn't account for old owners of the past. Then the bargain and sale deed. A bargain and sale deed is very limited and only has the covenant of season. A buyer gets no protection from encumbrances and doesn't assert that it's free of any liens. So this is most common in foreclosures where there are no promises. I'm sure you've all seen those HGTV episodes where the people go to the courthouse, bid on a house that they've never seen in person. Then when they actually get to the house after they own it, they see all these problems that are made in the house. There's plumbing issues, the roof is falling down and everything. It's too late, they've already accepted those risks. Then lastly, the quitclaim deed. This is the lowest form of a deed and it has absolutely no promises in it. This just transfers any interest the grantor might have, if they have any at all. This is most often used in divorce situations where the transfer is between couples. So they both bought it with the general warranty deed, so they both know all the things that have come with it. So when they're transferring it between the divorced husband and the divorced wife, they already know what it's about, so they're not too worried about it. You could kind of think of it as a quitclaim deed. Alright, let's move on. In North Carolina, attorneys conduct the closing. We are an attorney state, and this is actually a really quick time to point this out. We never practice law. We are not attorneys as real estate agents. Attorneys give the closing advice. Additionally, a title search must be done at closing and is a search of all public record. This is performed by an attorney. This will uncover a chain of title, which is a stack of documents recorded throughout history. The information within are things like liens, legal descriptions, and easements. Alright, let's discuss title assurance. Again, reading a little bit here. During title transfer, the seller delivers a marketable title, which is something that is free of unknown claims, liens, and defects, and this will be documented by an attorney. Furthermore, title insurance is something that a buyer or lender can obtain, which will ensure that the property is free of any defects and it's just one-time fee at closing. We'll cover this in other chapters, but just keep in mind that the seller is the one who pays the transfer taxes, also called excise taxes. Now we'll talk about recording, which basically just means that a document will be filed in the public records and now will be put on public notice. This way no one can undercut you and take the title. A deed is valid without recording but is not enforceable. So the NC Connor Act requires certain documents to be recorded, while the statute of frauds just requires certain documents to be in writing to be enforceable. Let's break down the difference here. It's actually really easy with another great acronym. So the other acronym you'll need to know is Dream Oil. All the letters in Dream Oil need to be recorded, while all the letters in Dream Oils need to be in writing. The only difference, as you can obviously see, is the S. And let me read them off. We have deeds, restrictive covenants, easements, assignments, mortgages, options, installment land contracts, leases longer than 3 years, and then sales contracts. So what doesn't get recorded? So the sales contract doesn't get recorded, as well as the offer to purchase. In general, we don't record documents during a transaction, but the interest at the end of a transaction. And now for the final review. There is no midterm in this one because we split up the two sections with a little bit of math. So first off, an informal property description is just your general street address. The description used on title must be adequately described. We do this in North Carolina with meets and bounds. Meets, again, is the distance, bounds is the direction. The government rectangular survey is used more often out west and is a grid-like system. There are townships made out of 6 by 6 sections. Each township is made out of 6 miles by 6 miles. And each of those little sections is 1 mile by 1 mile. Each section is 640 acres or 1 square mile. There are 43,560 square feet in an acre, and there are 5,280 feet in a mile. I still got it. To find the surface area of a space, multiply the length times the width. To find the cubic area, you multiply the length times the width times the height for that 3-dimensional space. When transferring title, there are 2 types: voluntary, like selling your house, or involuntary, which is like going under foreclosure. Testate is dying with a will, and intestate is dying without a will. When words end with or, they are the giver. When words end with e, they are the receiver. The types of involuntary alienation are foreclosure, adverse possession, which is when a trespasser claims your land and meets the requirements under ocean. Escheat is when someone dies without heirs. And eminent domain is when the government takes over your property through condemnation. There are 4 types of deeds ranging from the most promises to the least. You have general warranty, special warranty, bargain and sale, and quitclaim. And North Carolina is an attorney state, so attorneys conduct the closing. Lawyers also perform a title search to make sure that the title is clear of any liens and easements. And Dream Oil represents all of the documents that need to be recorded, while Dream Oils represents all of the documents that need to be in writing to be enforceable. Guys, I get it. The further that we get into these lessons, the more you might be thinking it's too much, it's getting crazy, but just take a deep breath. Just know that many of these chapters come together more and more as we start going through them. Right now in these early chapters, everything is still kind of fresh, but as we go to future chapters, we'll be referencing a lot of these older concepts, and that connects everything. So it's also not a good idea to get too far behind, as this is foundational. Listen, thank you so much for watching this video. I really hope that it's helping you all. Give me a thumbs up if you enjoyed it. Remember to hit that subscribe button down below so you can keep up. Also, grab your 10% off of real estate courses using the link down in the description below. I will see you all, each and every one of you, on the next chapter. Thanks.